Welcome everyone, and thank you for joining us for our presentation today, Life Without Me, Can't Imagine Such a Thing, part of Kerby Centre's ongoing series of online health and wellness, financial management, information, and entertainment presentations. As we gather here today, it's vital we also remember the peoples who've gathered here for millennia. This is the Treaty 7 land of the Indigenous peoples of Southern Alberta, the Blackfoot Nations of Siksika, Piikani, Kainai, and the Tfsa First Nation, the Stoney Nakoda Nations of Chiniki, Bearspaw, and Wesley, and the historic home of the Northwest Métis and Métis Nation of Alberta Region 3. It is with the goal of reconciliation that we acknowledge the land on which we gather, and we thank the elders of these nations for their timeless contributions to this land. And this past year has been difficult for many of us. As we've watched events unfold, I think that has particularly opened our eyes to the reality that one day we may not be here. And what does that mean for our loved ones? While it's difficult to face and to discuss our wishes with our loved ones, today's presentation will show you how important it is to have your affairs in order and that your loved ones understand your wishes. Today, we're pleased to welcome Dr. Judy Stewart. A teacher before becoming a lawyer, Judy Stewart recently retired from the practice of law, which included practice in wills and estates. Judy's thesis for her Master of Law at the University of Calgary was about principal tools to protect wetlands and riparian lands in Alberta. In June 2016, Judy graduated with a doctorate from the Faculty of Environmental Design at the University of Calgary, where she designed a reflexive legal framework for bridging organizations in regional scale environmental governance and management. When not writing academic papers, Judy teaches post-secondary classes about municipal and water law. Judy was on Cochrane Town Council for 6 years as a councillor and 3 years as mayor. She has been an avid volunteer on local, regional, and provincial watershed stewardship groups throughout her career. Dr. Stewart, thank you so much for joining us today. And please tell us why it's so important to ensure that we have that conversation with our loved ones and our affairs in order.
Well, thank you so much, Colleen, for that lovely introduction, and welcome everyone who's on this webinar. I just want to say to everyone out there, when you hear my bio, you might wonder, what does she do with wills? While I was practicing all this environmental law, I did have a wills practice on the side, and I was able to get to know a lot of people in your situations who were wondering, why do I need a will? Why do I need a power of attorney and personal directive? And there's a lot of confusion out there. I've titled my presentation today, Life Without Me. I just couldn't imagine such a thing. And you know, it's exactly right. How do you try and imagine the world when you're not in it? It's difficult at the best of times. So that title actually came from a play I was in, where I played a really crabby old woman. It wasn't hard, my daughter said. And that crabby old woman had that line. She had the chance to walk up to the front of the stage and in front of a massive audience say, life without me? I just couldn't imagine such a thing. So that's what we're here for, is to try and imagine life without you. I hope that you will find this presentation entertaining as well as informative. And so let's get started. First, as every lawyer you've ever met, even lawyers who are no longer practicing will tell you, this isn't professional legal advice. If you want a will, power of attorney, or personal directive at the end of the day, please consult your own legal counsel. This information is very general in nature, and a lot of it is intended to get you thinking, more so than to give you any specific advice on your particular state of being right now. And my views certainly don't represent the Kerby Centre. And I'm sure once we're through, Colleen will be very glad that I put that up front. Also, I'd like to acknowledge the Alberta Law Foundation and also Anne de Villers, who wrote Will's Fundamentals and provided us with this background information that all lawyers were able to benefit from, and all the people who had their wills done were able to benefit from when she wrote it. Clip art and cartoon stock cartoons are in my presentation to make it flow and to give it some kind of oomph. Otherwise, it would just be a talking head. When I do this presentation in person, we have a lot of fun, but on a webinar, it's very, very dry. So that's why I use a lot of cartoons. And also there's internet images. And I have to say, without internet images, webinars can be dreary. So let's start with the cartoon. This is the sad reality of life. Or you might want to say, this is the good reality of life, depending on where you're coming from. Everyone seems to die. My parents died, their parents died, their parents died. It runs in the family is the conclusion. Well, quite frankly, it runs in life, and it's something we have to get used to. But for many of you on this webinar, talking about death, especially your own death or the death of your loved one or a member of your family, or losing mental capacity, entering something called a persistent vegetative state while you're still living, these things are horrifying. They can be very, very frightening. And I acknowledge that not everyone is comfortable even talking about this. So what we're doing today is we're not in a panic zone, because you wouldn't be here. If you were in the panic zone, you would be just hearing some really bad news, and you would want to get a lawyer right away to get your will in place. Or one of your family members has just been in an accident and you're in that panic zone. The comfort zone is not always easy. Some people live their entire life and never reach the comfort zone of talking about passing away. So where we're moving today with this presentation is to bring us into the learning zone, where we learn something about dying, losing mental capacity, or what would happen if you're in a persistent vegetative state. So the outline, there's really only two topics. What we're talking about is the very fact that for most of us, death is not by appointment. You never know when it's going to happen. So it's about being prepared, and being prepared to die. One of the things that you do, other than spiritual health, etc., is you create a will. Dying intestate versus dying testate is also important for us to understand. If you die intestate, that means you die without a will. If you die testate, that means you have a will, you've thought about things, you've planned for it, and you're prepared. The second aspect of dying, of not knowing when death will occur, is why you need to get a lawyer to help you prepare your will. There are all kinds of will kits, and in truth, you can write your own will today, and many of you may get a pen and write one after we've finished our presentation. But why do you need to get a lawyer to help you with this? I want to talk a little bit about that. The second aspect of today's presentation is that accidents are not predictable. You don't know when an accident is going to take place, whether it's falling down the stairs or a car accident or even COVID. You don't know when these things are going to happen. You can't predict them. So how do you prepare for a serious accident that leaves you mentally or physically incapacitated such that you can't carry on? You can't do the things you're used to doing. So the two subheadings under there are, what's an enduring power of attorney? An enduring power of attorney, just up front, so you get a hang of where I'm going here, is you give authority to someone you call an attorney to take care of your financial matters. Interestingly enough, right across this wonderful country we call Canada, your financial affairs are deemed quite a bit more important than your physical well-being. So your enduring power of attorney is for your financial matters, all those legal and financial matters that you take care of every single day of your life. If you're incapacitated, you have to appoint an attorney to take care of them for you. And then what is a personal directive? A personal directive is where you appoint an agent, someone who you really trust and know well, who would make sure that you have the same quality of life as that you would hope to direct for yourself if you were able to. So there's 3 different aspects to preparing for death and for accident: a will, an enduring power of attorney, and a personal directive. And so on with the show. Life without me, I just couldn't imagine such a thing. So basically, what I'm saying here is, can you imagine yourself like this? And most people can't. They can't see themselves. Like right now, I'm sitting here talking to all you wonderful people. Admittedly, I can't see you and interact with you, which is my preference. But can you imagine moving from where you are right now into this position and what that means? Trying to imagine yourself not in the world. It's very, very difficult. Another cartoon lays it out even better. A person who's on life support says he's coming by to do a feasibility study. Well, unfortunately for all of us, there is nothing like that. There is no good time to die, and you don't get a chance to do a feasibility study. So it has to be something that you imagine. You have to try and put that in your brain, what this is going to be like. And it's not easy, and it's not easy to talk about. Death is not by appointment. We all know that. We know death is not by appointment. So this cartoon is actually quite hilarious when you think of it. You arrive, and like everything else, you have to have an appointment. Right now in COVID in Alberta, in order to do anything, you almost have to have an appointment, and you have to be vetted and sign all kind of disclosure statements. Unfortunately, dying isn't by appointment. We don't know when it's ever going to happen. Who can make a will in Alberta? So if we do want to make a will and we do want to prepare, are you able to? Is it even possible for you to make the will? So first of all, if you're over 18 and you have mental capacity, then you can write a will. So I'm not sure how many of you are on the webinar, but if I asked you to put your hands up, how many of you who are here today are over 18? And most of the time, everyone in the room is going to put up their hands. But do you have mental capacity? I'm asking this in good fun, but I'm also asking it as a legal question. To have mental capacity from a legal perspective is quite a bit different than having mental capacity from a medical perspective. And most of the time, it requires 2 medical practitioners to determine if you have mental capacity. But when you go to see your lawyer to make your will, you don't bring your doctor with you and you need no certificates. The lawyer has a checklist and they ask you all these friendly questions. And you might say, boy, this lawyer is extremely nosy. But actually what the lawyer is doing by asking you about how you got there and if you understand what you're doing today, and all of these questions are just meant to help you explain you have mental capacity. And the lawyer, through this conversation and friendly discussion, can quickly determine if you are able to make your will if you're over 18. And that's usually pretty easy to tell as well. The gray hair stands out. A person under 18 who has mental capacity can make a will under a few conditions. If the person has or has had a spouse or is in an adult interdependent relationship, then that person is deemed to be of legal age sufficient to prepare a will. If a person is a member of the military, I can imagine you understand why that is, or if the person is authorized by an order of the court. So sometimes you can have a court order that allows you to make a will, even if you're under 18. If you die testate versus intestate, I've already explained that to you. What it means is that when you die and you're leaving behind an estate, it's just a bunch of stuff, okay? All your stuff. I want you to think about your stuff for 1 second. Right now, I'm living in Victoria looking after my grandson, but I left behind my house. I left behind my husband. I left behind everything to come here and take care of my grandson. And it's all my stuff, my teacups, my collections, all my legal files. What you leave behind when you die is similar. You leave behind what's called an estate. An estate is all your real and personal property wherever it's found. And that's all an estate is. So when you die, all of a sudden, all that stuff is left behind. When you die testate, it means that you have decided what you want to do with your stuff. If you die intestate without a will, that means that you have not had the opportunity to explain where you want all your stuff to go. So here it is. There is this fellow, and I'm sure in your lifetime you've met someone like this fellow, with all his stuff. All of these things are important to him. And all of this stuff, his cat, all of the stuff he has is valuable, has a certain meaning, a spiritual connection, a relationship has been built up. That's why he still has it in his possession. And some of it might actually be quite valuable. He might have millions of dollars worth of knowledge in his computer. So you can't judge an estate by its cover. You have to delve into an estate and see what's in it actually. But death takes this young fellow out of this picture, and what is left behind? All the stuff. And you're leaving it behind, and somebody has to deal with it. They have to give it to a loved one, they have to sell it, they have to get rid of it. So my advice to everyone who used to come and see me was get rid of as much as you can while you're still alive. The number one reason why you needed to die with a will, why you need to die tested, the number one reason is when you prepare a will, you are a testator and you make the decision about where your stuff is going to go. When you die without a will, your estate is distributed according to Part 3 of the Wills and Succession Act. That means that anything that you own, including things like bit money, whatever that is distributed according to the Wills and Succession Act. And there are certain rules and regulations. You don't have a say. Property. So what is your property? I call it stuff. Property is stuff. I mean, we all can relate to that. I have my in-laws' teacup collection. That's property. But what is property for the purpose of the law? Let's go through it. It's real property. It's things like your house and your land. It's personal property like your diamond ring and your car, things that aren't attached to the land. It's your right and interest in all of the real and personal property. Things like shares and receivables that you have coming to you down the road. As well, it's anything that's regarded as law in property and in equity, such as those bitcoins and air miles, things that, before never had any kind of value whatsoever and are not real and they're not something you hold in your hand. Any right or interest that can be transferred for value, for example, if you have a water license attached to your property or a registration, if you are a rancher, that is property that can be part of your estate. Any right, including a future or contingent right. For example, if you have a lottery ticket, that's property for the purpose of your will and the law. Any cause of action. So if you have a lawsuit on your way and for a physical injury, for example, then your damage award that may be out there in the system, the court system, that would also be considered property for the purpose of your will. Your property actually reflects what you value, and it's every single thing that you've accumulated over your lifetime. So many people tend to think of it as their house and their car and their bank accounts and their guaranteed investment certificates. They tend to see it as something very tangible, but it also reflects all those pictures and all your cutlery and your diamond rings. It's all, everything you own. Some of it you place more value on, obviously, and some of it you place less value on. And so how you want to distribute these things can be different. Property that doesn't become part of your estate when you die. There's certain things that you own right now that don't transfer into your estate at all. And you should know about these things because you might think that you have the ability to write a will that gives these kinds of property to a beneficiary. But quite frankly, you don't own them after you pass away. Your joint property, personal or real property that has a right of survivorship actually just transfers automatically to the survivor. So for example, if the title to your house is owned by both of you, it's joint property. If it's owned by your spouse and yourself, or you and one of your children, or you and somebody who's not even related by blood, when you pass away, that other person who you've owned this property with for years just automatically inherits it. Property that you've already designated in your investments, your pensions, your life insurance plan, etc., that's all outside your estate. So there are all these mechanisms whereby you can make sure that things that you own go automatically to somebody, to a beneficiary, without having to put it in your will, because the will, quite frankly, will have nothing to do with these kind of jointly owned or automatic transfers. There is a resulting trust issue that you have to be aware of, and that's when somebody gives you something and you use it throughout your life. You think you own it, but you actually don't, because it would bounce back to the original owner. Now, the resulting trust is an issue that you might bring up with your lawyer if you're writing a will and you believe that you may have something that you own that would result in a trust relationship. This is where children buy something for their aging adults, like a condo or whatever. The aging adult doesn't own that condo. They have been able to use it throughout their lifetime, but the actual ownership bounces back to the person who buys it. So we don't have time to discuss a resulting trust in any detail, but it is something to be aware of. In fact, if you have a complex estate, if you have an estate that has items coming in, personal, real property, business assets, lots of investments, you may actually require advice from a tax lawyer and definitely an accountant. So you should be aware that seeking the tax advice early and even before you approach a lawyer to help you with your will is really, really important. There are tax implications because when you pass away, what happens legally is the whole world considers that now there are two entities. You've passed away, and your estate. And basically your estate is everything that you owned up until the moment of your death. And your estate actually crystallizes. What you own becomes your estate the moment you pass away. So it's very, very complex. You actually, on the year that you passed away, you have to file two different tax forms, one for yourself and one for your estate. Most of the time, it takes way more than 1 year to probate and finalize your estate. So you might not pay the taxes for your estate for some time in the future. But these are all very complex taxation issues. And so you should seek tax advice very early before you start writing a will. Now, here I am going on about taxes, and we haven't even covered off the issue of death. But what I want you to know is that it's been known for centuries that there are two things that are certain in life. One is there's going to be a time when we pass away, and that throughout our lives, we can expect to be taxed. And so Benjamin Franklin solidified it a little further when he said, in the world, nothing can be said to be certain except death and taxes. So get tax advice early. You don't want it to be something where you're leaving behind an estate for your beneficiaries that's associated with extensive taxes, so that in the end, they get nothing. You have to make sure that you've managed your estate and planned your estate well, so that the taxes aren't unbearable. And then I love this cartoon to sum up that whole discussion. If death and taxes are inevitable, how come we never hear about the death of taxes? Well, I'm sorry, folks, we are never going to hear about that. The basic facts are the wills, these things we write, where we decide, we make certain decisions about our property after we're in the grave. That this piece of paper is administered by somebody else, and the determinations of where things go. This is all very complex and didn't exist, something we've come up with. We've evolved as a society to be very complex, but the basics of wills are very, very simple. So basically, when we started to accumulate things like knives and tables and chairs and cloaks, we wanted to pass them on because sometimes they were very valuable. But nowadays, everything is so complex. And we don't even know what we own, quite frankly. We've never really had anything evaluated. We don't know if that picture on the wall is worth much. We have a very complex society. So we made innovations called wills. And it's based on this idea, this liberal idea, that the value of an individual and their ability to own property was something that we had to be able to protect. That all the stuff they own shouldn't just be left on the side of the road when they passed away, but should be distributed. So it gave the person the power to control where their property goes after they pass away. It provides a sense of personal immortality to the individual. So a person can feel that they have a say, even though they've passed away, that there's some kind of immortality, that their things will live on. Quite frankly, a lot of people try and use this sense of personal immortality to control their beneficiaries after they're dead. This doesn't work. You really can't control what somebody does with their inheritance. You can try to do that through your will, but it's certainly not something that I recommend. So to sum it up, when you're living, you're accumulating stuff. When you die, your stuff has to be distributed, and you want to have a say on how that's done. And to be quite blunt, dying is the last thing you're ever going to do. So once you pass away, you have to leave, you have to trust society, you have to trust your will, you have to trust your executor and your trustee to make sure that your wishes are respected. A will doesn't have any effect until you die. The will takes effect immediately upon your death. Okay, so if you have a will, it doesn't matter as long as you're alive. As long as you're alive, that will is irrelevant. As long as you retain mental capacity, according to lawyers, you can change your will at any time. And I'll tell you, I have one client, of course I won't reveal any names, who has changed her will at least 25 times in my practice. As long as you retain mental capacity. The last time this person asked me to change her will, I refused. Because at this point, I'm not sure if she still has the mental capacity. I think she just liked the relationship she had with her lawyer and enjoyed coming to see me. Can you imagine that? Anyway, the last will that you make revokes all your previous wills that you've made. So the last time she came before me, all those other wills went out the door and only the new will is relevant. The old wills are usually ripped up and thrown away, but the lawyer does keep them. The lawyer will keep all previous wills to see a progression, to see if maybe you have lost mental capacity, and also because they have to be able to look at what your ideas were all along the way and how you may have changed over time. A will is interpreted by the courts as if it's been made immediately before your death. So even if you made it 10 years before, the courts look at it as this was made yesterday before this person passed away. A will enables you to appoint what they call a personal representative nowadays, but what most of you will understand to be your executor. And the executor also is your trustee in most cases. If the person who you establish as your executor doesn't live in Alberta, then your trustee may have to be somebody else. And you can ask your lawyer about that. And that's because of the law, the laws of trust in Alberta. You have to be an Alberta citizen in order to manage an Alberta trust. But it's a very complex area of the law. And so if you are in the position where you're going to be naming an executor who doesn't live in Alberta, then you need to discuss that issue with your lawyer. So the will helps you to appoint this person who is going to execute your estate, person who's going to distribute your things and make sure your taxes are paid, make sure all your debts get paid. That's your executor. So quite frankly, the first thing they do is they arrange for payment of legal debts, all your funeral expenses and taxes. And your executor is not necessarily the person who's in charge of your funeral. And my suggestion is never put funeral arrangements, what you want for your funeral, in your will, because the executor is going to come onto the scene after your funeral. And maybe they will have done things completely opposite to what you have put in your will. Some people want no funeral. Some people want to be cremated and their ashes distributed. Put that in a memo or put it in a letter to the person who you know is going to take care of your funeral, and let them know ahead of time, because your executor is not necessarily the person who's going to arrange your funeral. But they are going to have to pay your funeral expenses. They sure are, because all of that comes out of your estate. It doesn't come out of your spouse's funds or your children's funds or anybody who's arranged your funeral. It comes out of your estate. A will also helps you to name your beneficiaries. Who do you want to get your stuff? Generally speaking, you should know this well in advance. And you don't want to be discussing this in front of your lawyer, because the lawyer, let's face it, is looking at their watch every 6 minutes. All right? You want to know this. You want to be clear. What do I want to leave behind for Susie or for Johnny or for your canary? All right? Who are your beneficiaries? Name them, and what do you want them to receive? Do you want them to have an equal share of your estate? Do you want your estate to be held in trust for your infant children? What do you want? And if you can clarify that well in advance, that's going to be helpful to everybody. You can establish trust through your will. For example, the trust fund for your children's education, that can be put into your will. It also gives you the right to name certain powers that you want to give your personal representative, your executor, because your executor doesn't have powers outside of the law. And if you want your personal representative to have powers outside of the law, you have to say what those are. Those can be the power to keep your house the way it is for as long as they see fit so that they can maximize the profit from your home. Ordinarily, they can't do that. On the day of your death, that house goes into your estate. And the way the law stands right now, they have to get rid of your house ASAP. But what if you don't want that to happen because the market's terrible as it is right now in Alberta? So if you give the power to retain your will until they see fit, that's a very important power to give your personal representative. And there is a whole list of them. Also, the will is the place where you name a proposed guardian for any minor children that you may have. So there are a whole bunch of considerations around who do you want to take care of your children if you should be gone from the scene. Your children aren't your possessions, but it's important that you get to name who you want to look after them. It may be a sister or a brother. It may be a grandma or grandpa. It could be anyone who you want to take care of your minor children if you should pass away suddenly. Anyway, this is often the situation. I know it comes across as a really funny cartoon, but I have actually had someone come into my office and they want their will to look like they're leaving their family something, but they're actually not. They're trying to use their will as a punishment for something their children have done in their life. And I want to tell you right up front, in all seriousness, this is not a good place to do this. Having a conversation with your children and say, you know, I'm not leaving anything to you in my will is very, very important. And here's another cartoon that really hones in on it. I'm afraid, Mr. Walberry, that I know of no legal mechanism by which you can bequeath them all a swift kick in the pants. You can't use your will to punish someone who has really ticked you off during your lifetime, especially your children. And here, this is even more interesting. I love this cartoon. The dog and the cat walk out disappointed that the testator left everything to the parakeet. A will, as I've already talked about this, is not the best place to talk about funeral arrangements because it's often not even found till after the funeral. As well, the instructions on your funeral are not legally binding. So what's the point of putting in your will? It's much better to tell the person who you know is going to take care of your funeral upfront what you want. And you can tell them things like burial versus cremation, whether you want a headstone or a marker, whether you want to have this big celebration of life. You know, some people have it, they discuss it, they have it so arranged with funeral services up front that the person just has to go to the company where all the pre-arrangements have been made and just arrange to have your body brought there and everything is taken care of. I'm not suggesting that people do this. Honestly, funerals are for the living. Why do you care? You're not there anymore. But I know a lot of people who have already done this down to the verse from the Bible they want read and the music they want to be sung. And if that's your way of being, certainly go ahead and do it, but make sure that the person who's going to be taking care of your body once you're left behind, once you've left, basically, because you won't be there, knows what you want. Discuss it. It's very important to discuss this. Sometimes you can leave a memo with your children and say, don't open this, or with your spouse, don't open this unless I'm pass away. And then if they remember to open it, you can have all the instructions there. I know my mother-in-law has given my husband a whole binder of instructions for what she wants, and it's extensive. The other issue is safety deposit boxes. A lot of us have them. That's where our will is kept. The lawyers tell you keep this will, so in a fireproof container and a safety deposit box. That's all well and good, but What if the person, the personal representative who you've named in your will, doesn't know that you have a safety deposit box? So let them know where the box is and where you keep the key. And then all you have to do is bring a death certificate. All the personal representative has to do is bring the death certificate and a copy of the will, and they can access your safety deposit box for anything that's in there. If you're like me, you have things in that safety deposit box from when you were 20. I suggest if you're thinking about making a will, go in there and get rid of it. Don't do like me. Be like Bob and clear out things that are, I have titles to, my first car, things, ridiculous things that we tend to still value because they have sentimental value. Get rid of all that stuff. I suggest if you have things that you, specific things like my teacup collection, and you want somebody to have them when you pass away, give it to them now. Once you're at that stage, over 75 or whatever, just start giving stuff to people. Another little tactic that people do is they take a little sticky and they put it on the back of an object or underneath and says, this goes to so-and-so when I pass away. Then your executor doesn't have any question. They know that that's where you wanted that thing to go. Otherwise, you know what's going to happen to it? It's going to go in an estate sale. And who knows who's going to end up with it. In fact, 3/4 of the teacups in my collection come from estate sales. So don't be like me, be like Bob, and make sure you have everything organized. Estate tax is a really big issue. And I know you'll want to talk about estate tax with your lawyer. And I'll just tell you up front, there is no estate tax in Alberta. This was replaced in 1972 by a capital gains tax, and it's still in place. So instead of saying to your lawyer, I want to discuss estate tax, talk about capital gains. And you might want to talk to your accountant up front about capital gains as well. On death, as I said before, there's an immediate deemed disposition of capital and certain depreciable assets. So that means right away, it's deemed that you have sold these things. And so any value that has, so for example, say you have an antique car. Well, it had a certain value when you bought it, but as it got older and older, the value has increased. So you now have a capital gain if you were to sell it. Well, that capital gain is taxable. I'm not going to tell you about taxes too much because I want you to seek out tax information from a qualified professional. As I say right now, I'm not even a practicing lawyer, so I don't want to give you any kind of legal advice today. I'm just trying to give you some general information. Your property is deemed to be sold immediately at your death for fair market value. So say I die in a second, anything that I own just before that second would be deemed to be sold for fair market value. What would that teacup collection be worth immediately before I just passed away? And it's a fair market value. So it's not something that you just come up with. It's something you have to go out and look at in the market system. So this makes any untaxed capital gains that accrue during your life taxable in the year that you died. So this is why I was saying you don't want to leave an estate that has all of this capital gain that your poor beneficiaries have to deal with, meaning that they won't even receive anything. Everything in your estate will simply go to taxes. It's very important for you to talk to your accountant and talk to your lawyer about possible taxable capital gains that have accrued during your lifetime. The other thing you should know is some of your property is exempt from capital gains. And this is asked of me so many times in my practice. Your house, the principal residence, you can only have one of them, but that property does not attract a capital gain. So this is especially important for many of you on the webinar who have lived in the same house since the early 80s and your house has already, increased in value, and you're going, I bought it for 90,000 and now it's worth 600,000. That gain is not, it doesn't attract a capital gain if that's where you have lived. Spousal rollovers. So there are certain conditions that apply, but if you have, for example, an RSP that rolls over to your spouse, it is capital gains exempt. If there's a trust rollover, like a spousal trust that you have created in your lifetime, that doesn't attract capital gain. And as well, a farm rollovers. Now, the farm must qualify, and it can roll over as a spousal trust or to a child of the testator. So there's only certain people who can benefit from a farm rollover. And there is a capital gains exemption of 500,000 for certain property, such as this farm property I'm talking about, and shares in some small businesses. This capital gain exemption, where your estate would be exempt for the first $500,000 of value, is a highly regulated system. And I don't pretend to understand it one single bit. But this is, again, where you would go and talk to a special tax advisor if your estate is very, very complex and you have accumulated capital gains. Dying doesn't eliminate your debt. All right, your debt doesn't go away. Your debt belongs to your estate. It doesn't belong to your wife. It doesn't belong to your children. It doesn't belong to your grandchildren. But your debt belongs to your estate. This is a cartoon I found that I thought was great. Makes the point. I saw the bright light in the tunnel, but they sent me back because I haven't paid my student loan. Well, it's not like that, but your estate has to pay your student loan. So by now, you probably already know the answer to this question. Why do you get a lawyer to help you prepare your will? Well, first of all, the lawyer understands the complexity of all the law. My wills and estates binders were, they're huge. It's a huge amount of Alberta law that you have to understand, including farm property law, real estate, all kinds of laws, notwithstanding divorce law, family law, interdependent relationships. So the lawyer understands all of that. So as soon as you give them your fact situation, your lawyer can then say, here's all the information I need to put together to make sure this will is valid and will be upheld by a court if it's probated. So it's important to understand that the lawyer isn't there just to make money. Sometimes they are, but let's not say that out loud. But they're there to help you wade through all the complex laws that may affect your particular situation. If you are 18 and have mental capacity, and when you present yourself to the lawyer, they're going to make sure that you're making your will voluntarily. For example, that your children haven't decided that they want you to give them your house, all right? They want to make sure that you're there voluntarily, that nobody has put pressure on you, and there's no coercion or fraud involved. This is so important if you're elderly and frail, especially if one or two of your children, and let's face it, some of our children can be a real pain in the butt. They all of a sudden think that, okay, mom's losing it. I'm going to get her to a lawyer pronto and make sure that she signs all these documents. You know what? The lawyer's going to know if you are being pressured and if there's coercion. And they also will make sure that you understand what you put in your will. They're going to make sure that you understand tax implications, anything that you don't understand. They'll go through that will with you page to page a number of times until you are happy. Most of my clients left happy. And if you can have a client who leaves your office happy, you know that the administration of that will is going to go very, very well, and there won't be a lot of tension. It's a conversation that you have with your lawyer. Some people say, well, A will is something, you know, I'll do it for you for $250, and then they give you a form will that doesn't reflect anything about you. Find a lawyer who's going to talk to you and treat you as this unique person, and all of your stuff as valuable and important to you, because that's the kind of conversation that's going to let you leave the lawyer's office feeling really happy. A lawyer, quite frankly, cannot take instructions for your will from somebody else. So if your daughter comes in and says, this is what my mom, or this is what I want to do, or the aunt comes in and says, well, you know, this is what this child needs to do, they can't take those instructions. Once you lose mental capacity and you can't give your own instructions, you simply cannot write a will. Same is true for your power of attorney and your personal directive. You know, nobody can give instructions for your will. If you have an attorney, they can't give instructions for a will. If you have an agent, they can't give instructions for a will. Your instructions have to be given by you, independent of others, and the lawyer has to make sure you understand your own instructions. Okay, they'll go over it with you 5 or 10 times if you're doing something very unusual. For example, trying to leave everything to your parakeet. They will go over that over and over and over to make sure that's really what you want to do. But ultimately, what you want to do with your stuff is your decision, and that will be reflected in your will. A word about beneficiaries. The people who you want to leave your stuff to, sometimes they don't want it. All right. Sometimes they don't want all that stuff. Like, for example, children no longer care about silverware and fancy china. I have an antique thing that was given to me through my family that's probably dates back to who knows when, and nobody wants it. I don't know what I'm going to do with it. So your beneficiaries might be ungrateful, all right? And they also might be disappointed. You know what? Who cares? You're not going to be here anymore, all right? Try not to cause fights, but it's like this cartoon says, I'm afraid your grandparents' last will and testament will be a great disappointment for you all. I know you expected the world. Let's face it, for many of us, once we have a RIF, once we get to that retirement income fund stage of our lives, there isn't very much left. And there isn't a lot to leave behind for our grandkids. So don't even try. What you can do is, while you're still living, send them $500 at Christmas, or send them a nice little trip somewhere while you're still alive. Don't try and do it through your will, because you need that money. Up until the day that you pass away, if you are living on a fixed income or have very little of property, enjoy it. Quite frankly, they don't even need it half the time, okay? So don't worry about your beneficiaries. Do your best. A lot of people say, I want to avoid probate. I want you to write this will so it never has to be probated, that I can just get rid of my stuff and it doesn't have to go to probate court. Well, you can do that. Like I say, you can get rid of everything while you're still living so the will doesn't have to be probated. But that includes your house. It includes all of your RIFs and RSPs. If you have an investment portfolio, then your will have to be probated. If you have a house, your will have to be probated. So this cartoon is perfect. So daddy doesn't know why birds migrate, but he can tell you so many ways to avoid probate. There are lots of ways to avoid probate, but my question to you is why? Probate fees, to actually, what does probate mean? I guess I didn't say that. I better say that right away. Probate means taking your will to a court system, and they authenticate the will and make sure that this will can be put in place, can be executed by your personal representative. A lot of people don't want that step. They don't want their personal representative to have to go and get their will probated. But where is the harm in doing it? The court system is there to make sure that that will is authentic and can be distributed as written. And how much does it cost your estate? Look, if the value of your estate is $10,000 or less, it costs $35 to probate your will. If your estate is humongous, $250,000 or more, up into the millions, it costs you $525. The cost of probating are insubstantial, and they are going to help, the court system will help to make sure that your will has been done in such a way there shouldn't be any arguments down the road. So, and it also protects your personal representative from any suits that things have been done incorrectly. So to summarize this whole thing on the will, and then I'm going to ask Colleen how much time we have. The testator, you designate a personal representative. The will takes effect only upon your death. The personal representative has only the powers that you give him or her through the will. And the personal representative is not always your attorney under a power of attorney or an agent under the personal directive. The personal representative is named specifically for the will, and that personal representative has nothing to do with you until the day you die. Okay, they don't manage your affairs, they don't intervene on any of your decision making. They only step in to manage your estate upon your death. So Colleen, oh, I'm sorry, and it's your personal representative who will probate your will. So they will know in advance what kinds of property you have and how difficult it's going to be to distribute your property. So Colleen, do we have much time?
We're about an hour. We'll take some time to take some questions here if you're done with your presentation.
So I'm going to check my phone here. It's 10:30. We were going. Sorry, it's 11:30. So the people on the webinar, do they want to go on with this or just go and have a few?
We can carry on a little bit, and those that would like to ask some questions are welcome to. People will leave if they feel that they must, but
so I'll try and go really quickly through this, Colleen, because basically it's just talking about the attorney and the agent under power of attorney and personal directive.
Okay.
No, is that you can have three different people involved with your with your life. Under a will, you appoint you are the testator, and you appoint a personal representative. Under a power of attorney, you're known as a donor, and you appoint an attorney to look after your financial and legal affairs. Under a personal directive, you're called the maker. You make the personal directive, and you appoint an agent. And the agent takes care of your body, your physical well-being. They make sure that you live in the place where you would want to live, your hair is done the way you want it done, your nails are done, whatever it is. The agent looks after you, that you get the kind of food you need, that you have a safe place to live, etc. So here you go, here you are. And you are a testator, a donor, and a maker, and you get to appoint three different people to help you, because accidents are not predictable.
Wow.
This is the reality. If you were in one of these cars, you would either be dead, but what if you weren't? What if you were mentally and physically incapacitated a second after this? Who's going to take care of everything? Who's going to look after things for you? So this is where you name a person to look after your legal and financial matters, and a person to look after you, however you are, in a wheelchair, on life support. Okay? You can't predict this. I've been driving down the road and I've seen this. I'm sure all of you are aware that this is a reality. With COVID hovering over us all, we don't know. It could happen to anybody at any time. So what's a power of attorney? We've gone over it more and more. It's very important to know that if you become mentally incapacitated or infirm, as they call it, this has to be determined by a medical doctor. The person who you designate as your attorney under an enduring power of attorney can make the decisions for you about your legal and financial affairs. Very important to understand, legal and financial affairs are completely different than your person in a wheelchair, your person in a hospital bed, your person on life support. The person who you've appointed as your attorney can't do that. Now, of course, your husband or your wife or somebody, your child, they can take care of your body. But if you have this agent, you selected a person to be that agent for you, it's going to be even better, and they're going to be able to do a lot more for you in a hospital situation. So here's make a light of the whole thing. There's a person sitting around the table and they go, well, I have the power of attorney, because they might not, who are you? Well, I have a power of attorney. So I'm therefore at this business meeting on behalf of the person, the donor, who appointed me as the attorney. And this happens where all of a sudden you step into the shoes for legal and financial matters. You're the donor of a power of attorney. That means you, the person who writes the power of attorney, you donate, you give all your rights, all your legal and financial rights to the attorney to act on your behalf. And what you have to understand, the person who you appoint as your attorney is not always a lawyer. It's often a family member, okay? It can be a lawyer, but the word attorney is often very confusing to people, and they say, well, I want to appoint my lawyer, and your lawyer goes, wait a minute, no, I don't want to be your attorney. It's just the word, like an executor. The attorney under a power of attorney is often a family member. And before a person can be designated as your attorney, you have to have mental capacity. So once you're in that accident, you can't make a power of attorney. You have to have mental capacity to make it. And it's a good thing to get it in place ASAP, because if you are worried about your health, you want to make sure there's somebody who will be able to step into your shoes. And what is a personal directive? Well, it's what we used to call the living will. But the government of Alberta put in place a Personal Directives Act. It's a piece of legislation to make sure that these living wills have a certain form and a certain flow, because people were coming up with all kinds of living wills that were, quite frankly, not enforceable. Nobody could use them, especially institutions. Most institutions where you might want to go live, for example, what I used to call an old folks home, now we call retirement homes, etc. They require that you have a personal directive in place. And a person with mental capacity, so it has to be while you still have mental capacity, you appoint someone called an agent, and they can make decisions about your person, where you should live, what kind of medical treatment you might undergo. And this is also helpful because if you're diabetic or you need certain regular treatments, this agent will know about those and make sure that you get the correct kind of medical treatment that you need. Here's the best cartoon on living wills and personal directives. I thought it was great. And so I'm going to read it with you. I hope you enjoyed it as much as I did. Last night, my sister and I were sitting in the den, and I said to her, I never want to live in a vegetative state. How many of us have said that, right? I don't want to be dependent on some machine and fluids from a bottle to keep me alive. That would be no quality of life at all. If that ever happens, just pull the plug. So she got up, unplugged the computer, and threw out my wine. She's such a bitch. So, No, I think it sort of sums it up. We've all said it.
Love Maxine.
I don't want to be kept alive. I don't want to be on life support. But right now, with COVID, more and more we are seeing family members who are on life support. And if they have appointed an agent, that agent will have instructions for what that person wants. Do they want to be kept alive? The doctors are not going to kill you. They're not going to just pull a plug. Even if you put it in your personal directive, but they can help make those last moments of your life much more pleasant if they know, all right, what kind of drugs you want. So this is it's making light of it, but it's important to let people know so that they're not making that decision on your behalf. For example, I had a young nephew who was in a motorcycle accident, and he was what they called in those days, brain dead. His body was in perfect shape. He was an athlete. And so the dad, my brother, and his wife were asked if they could harvest all his organs. And they didn't know what to do. They kept him on life support for a couple of weeks, and they checked into everything, hoping that maybe he, miraculously come back to life. And they didn't know. That's why it's important to fill out those donor cards. It's important to let people know what you want, because maybe there is something still in your body that's helpful, maybe even to medical science. So, fill out a donor card if you don't have one, if you would be willing to allow part of your body to be used to help somebody else. Do that now. Persistent vegetative state is a common word that people talk about, and it's not defined legally, but it's basically a medical condition where they're unresponsive to any psychological or physical stimuli, and they have no sign of higher brain function, and they're only being kept alive by medical intervention on a ventilator or something. Some people are put into this state to keep them alive so that their brain can heal or their body can heal. That's not what we're talking about. We're talking about there's no hope. No matter what you do, this person is never going to come back. So that's what persistent vegetative state is. So you want this agent to be able to make all these countless little decisions, like how long your hair is. I would write, my hair is usually a lot shorter. I haven't been able to go for a haircut. What kind of clothes you wear, what food, what medical appointments you go to, all these little things that you do for yourself that you can't do anymore. Make sure your agent knows your instructions, because quite frankly, what are your loved ones going to do? They want to do something for you, but they don't know. And do you want them to suffer and not know what to do? Make it clear, let them know, so that they don't have to go through that angst that my brother and his wife had to go through. If you don't have a power of attorney or you don't have a personal directive, your loved ones are going to end up here. This is a typical courtroom, and a judge will make the decision. The judge will decide who's your agent. The judge will decide who's your attorney. The judge will decide who's your executor, because you haven't made that decision yourself. So why put your family members in this scenario? I don't know if you look at this and think it's a place you want to be, but I'm a lawyer. I don't want to be there. This is an American courthouse, by the way, but ours look very similar, if not even more daunting. So I tried to find one that wasn't as frightening as some of the courthouses in Alberta. Courts are not pleasant places to be in, and you are being judged. So you don't want to put your family members here. Quite frankly, nobody wants to end up here. So make it simple, make it easy for them. Now, probating the will never gets into a case like this if the will is clear. Probating the will is done administratively, and behind the scenes, a judge looks at your will, looks at the documents that have been prepared and sent in by your executor, and stamps it. So you don't end up here when you probate most wills.
Well, we've got...
With your legal counsel, how the process starts, an interview. You're usually required to fill out a will questionnaire, and the cost to prepare all of these documents varies. Some firms offer flat rates and packages, and I suggest you go with one of those. And now it's time for questions.
There we
Sorry
go.
about that, Colleen.
That's okay. We've got some questions coming in here. If you'd like to, there we go. Yeah, we've got some questions coming in, and I think that a great presentation. Thank you very much. Wonderful information to really hit home the fact that we need to have that conversation, and your humor throughout really helps to kind of take the sting a little bit out of having to have that conversation and some of the things that we do need to make sure.
Okay, so were there other questions that
Yeah.
came in?
Yeah, I'm going to, we've got a few questions coming here through our Q&A. I would welcome anyone that has questions. Just go to the bottom of your screen and you can ask them through the Q&A function button. Just wanted to also just quickly say a welcome here. Today we have visitors from the US, some from LA and some from Georgia. We also have some visitors from Edmonton, and welcome to our visitors from Medicine Hat. We look forward to working with you here as we move forward with our presentations and working with Medicine Hat. Wiley Chan, does TFSA have designated beneficiaries?
I'm sorry, a TFSA?
Yeah.
I do believe they do. But you can certainly leave your TFSA to a beneficiary. So in your will. So that's a question that you should find out working with your accountant, or you can go on the federal government's website and look up TFSAs and ask that question, and an advisor will let you know if you can name a beneficiary. Those are things that are easy to put to frame around and say, I want this amount of money to go to this person. I can give you an example of my mother-in-law cashed in, she's 97, cashed in her TSFA and gave it to her daughter who she wanted to receive it before she died. I suggest to you that if you're 97 and you have a TSFA, cash it in and give it to whoever you want to get it. Don't wait for it to go through your estate and be taxed and everything else that might happen to it. But I do believe you can name a beneficiary of your TFSA.
Thank you, Dr. Stewart. Janice, is it better to identify an individual or the estate as a beneficiary?
Yes, you can do that. You can say you want your estate to be the beneficiary in any of your, any of your savings, any of your life insurance. Your estate can be the beneficiary.
We have another about the TFSA. Anonymous would like to know, does the beneficiary who inherits the TFSA be required to pay tax?
No, they don't. You can have actually a rollover of your TFSA. Basically, if there's a capital gain on a TFSA, they may have to pay. This is a question you need to ask an accountant, all right? I don't want to venture out and give any kind of advice that may be misconstrued because I'm no longer practicing. And according to the Law Society, I'm not allowed to say anything like that. So please consult with your tax advisor.
I think that was one of the pieces of advice that I hadn't really realized when I was preparing mine, to seek out those professionals, like getting tax advice when you're preparing your will. So, between your lawyers and tax advisors and that kind of thing, maybe asking those questions when you're preparing.
Go to the tax advisor early. If you have a TFSA and have any questions about it, get as much information as you can from the website. And then if you still have a lot of questions, ask your accountant.
Janice would like to know, what is the difference between a power of attorney and an enduring power of attorney, or is it just a change of term?
And enduring, most of the powers of attorney that are made now are enduring powers of attorney. What's the difference is that a power of attorney, you can give power of attorney for your bank account, for example, and it takes place immediately. An enduring power of attorney, you don't have to give. It allows you to see, this is kind of the information that I would give if you came into the office and I would say, please do an enduring power of attorney. Okay, I'll tell you what I would say. When you give an enduring power of attorney, what that means is that you have the ability, while that person has been appointed as your attorney, to write a letter at any time that they can take to a bank so they can act on your behalf, or that they can take to land title so they can act on your behalf. You give them the letter and the attorney, the power of attorney, and that allows them to act for you. What if you're out of province like I am right now? My husband can take my power of attorney and he can go and act on my behalf if I give him a letter. But if I become mentally incompetent, then I can't write the letter anymore. So that power of attorney kicks in automatically. It endures. So I don't have to worry about giving him a letter. He can just go automatically with that power of attorney and act on my behalf. So most powers of attorney that are issued now are enduring powers of attorney.
We've got a few more questions here. Linda, is your agent legally bound to form your directives in your personal directive?
I'm sorry?
Is your agent legally bound to form your directives in your personal directive? I think you create your own personal directive and then
they're not legal. There are certain signing requirements under the Personal Directives Act, but they're not legally bound. They can get out of being your agent if they want to. They can make a court application and be removed as your agent. But most of the time, if someone agrees to be your agent, they have to, at the end of every personal directive, there's a place where they have to acknowledge receipt of the personal directive, a copy of it, and they sign. So it's really hard to get out of them, but they can remove themselves from being your agent.
Okay, and Jill, thanks for joining us, Jill. Jill has said you cannot leave your estate to a pet. You can name an individual in your will to receive a sum of money to take care of your pet.
Absolutely, absolutely. That was a joke.
Donna, thank you. Fantastic information, Judy. Thank you. Anita, thanks for joining us today. Can your attorney or agent be out of the province or country?
Yes, they can. They can be out of province and out of the country, but anything they do on your behalf, they have to actually come here and act on your behalf. And they, especially your attorney, would have to put some kind of bond. They would have to pay a bond in order to look after your affairs. They would probably have to hire a trustee or somebody who is in Alberta to manage all your financial affairs, because unless they pay that bond, the government of Alberta doesn't want somebody from outside the province to abscond with wealth that should be addressed here in Alberta. So it's quite complex. Please don't name somebody outside the province as your executor or your agent. Try and find somebody closer to home.
Several accolades. Thank you, Judy. Great information. Great, Wendy. Great presentation. Love the humor. Made me realize I have some work to do for end of life decisions. Thanks, Judy, for your valuable information. I've got a couple more questions. Linda was qualifying. I meant to follow your directives. Okay. And the anonymous, can you give an average cost for the preparation of a non-complicated will?
That's what I was saying towards the end there when I was rushing through. It depends on the law firm. Some law firms treat wills as sort of write-offs. that they do them very cheaply because they want to establish a relationship with you. And once they establish that relationship, you might come for your sale of your house or for your divorce or whatever. So they use it as a lost leader, and they can be done very cheaply. But what you have to know is that in those cases, and I'm not saying all cases, in many cases, your will is being prepared according to a form, and they don't spend the time with you that you need to explain what you really want, to give your instructions. They don't have those conversations. You just fill out a bunch of paper and then go sign it at the end of the day. So you get what you pay for, generally speaking. Some firms will charge you $500 to for both of you, for husband and wife, because they're sort of almost the same. And other firms can charge you, by the hour. Don't go by that. Never do your will hourly because it would cost a fortune. If you have a very complex will, you're looking at a lot of time with your accountant, etc. Be prepared to pay up to about $1,000 for those. Most of the time, once you have that initial interview and fill out that questionnaire, your lawyer is going to be able to tell you the complexity and enter into a relationship with you, and they'll let you know up front how much they're going to charge you. So don't be afraid to ask. Say, will you do it for me for $500? And sometimes the lawyers take into consideration your financial situation and whether or not you're in a position to pay. And if they like you, they might do it. I've done so many wills pro bono that I can't even count. So, if you're elderly and you don't have a lot of money, check around. The best place to check is somebody who you know and trust. Check with somebody like your sisters, brothers, aunts, uncles, children. Who have they used? Do they like them? How much did they charge? Whatever you do, don't ever pay more than $1,000 for your will. And it should be a package. If you're paying up to $1,000, then you should get the power of attorney and the personal directive included, plus a lot of legal advice and tax advice. So, we paid about
shop around and go to someone you trust.
We paid, my husband and I paid quite a lot for our first will, but then we went to the lawyer and had a lot of arguments. We were very young, and I wasn't practicing law at the time. And this guy couldn't stand us anymore because we had arguments about everything. So don't argue in front of your lawyer. Whatever you do, have everything clearly laid out, know what you want, go there to have questions answered.
All right. I think that we've, Elizabeth, I see that you had your hand up there, but if you have a question, perhaps maybe you could put it in chat or Q&A, and we've run over quite a bit, but great information, and we still have the majority of our guests joining us. So obviously people are appreciating the information. So thanks for bearing with us as we've gone on. If we have no further questions coming up, I'm just going to do a quick screen share here as well myself, and then we'll wrap things up. Dr. Stewart, thank you so much for such a great presentation, great information, and loved the humor. Thank you. That makes the subject just a little bit easier. So just quickly go through what we have coming up here, and for anyone that joined us on the 3rd for the peer group discussion, or for the Good Mental Health Habits for Seniors presentation, the peer group discussion takes place tomorrow at 10 a.m. And if you've not registered yet, registration is still available till tomorrow morning, and Vanita will get in touch with you. The capacity is limited, so if you would like to join that, then by all means register on Eventbrite ASAP. Sorry. Oh, what's going on here? And so also just quickly, and I just realized what's going on. I'm sorry, I've kind of bopped through there too quickly. So also just wanted to make sure that you're aware that Information Resources also has legal and tax advice available. So feel free to call Kerby Centre. We are effectively closed to the public at this point, but our programs are still operating. So if you need some assistance with legal or tax advice, by all means, give us a call, and or any of our programs and services are available to you. And 2021 memberships are available. As I mentioned, the income tax clinic is going to be operating March 1st to April 30th. We will be doing a presentation in March with Bonnie McIntyre once again, specifically on tax credits for seniors that might help you. But if you would like to arrange to have help with your taxes this year, 403-705-3246 to make an appointment. And our next presentation coming up, Women's Heart Health, February 18th, is I think going to be of great interest. Of course, February 14th is Valentine's Day, and on February 13th, we celebrate Wear Red for Women's Heart Health. So we hope that you'll join us on the 13th to wear red and tune in to some of the Libin Cardiovascular Institute presentations that will take place that day. And then join us on February 18th as Dr. Cara Nuremberg discusses women's heart health. And it's not just for women, it's for those who love them as well. And on the 23rd, our virtual Chinese New Year celebration should be a lot of fun. As you know, we typically do that in our auditorium, but unfortunately this year we're going to be doing it virtually. All of the registrations are available on Eventbrite. And I seem to have lost Dr. Stewart. So I think that we can consider this a wrap today, and thank you all very much for joining us once again. And we look forward to seeing you next time. Thank you.